Have you been convicted of a crime in the state of Texas? Well, hear me out. I've handled a ton of cases with post-conviction issues. I've had post-conviction cases overturned on both appeal, motions for new trial, and writs of habeas corpus. And I'm going to tell you what you can do in order to help your case after a conviction. So today, what I really want to focus on is motions for new trial. In the state of Texas, there are multiple avenues of filing certain documents after a conviction or plea agreement of where you've pled guilty or a trial of where you've been found guilty. Whatever the circumstances that may have happened to you, what you could do is, number one, file a motion for new trial as long as it's within the first 30 days of judgment. Number two is obviously a direct appeal, which is also filed within the first 30 days, but all that is simply a notice of appeal, and then certain deadlines start running afterwards. Or a writ of habeas corpus, which could be filed at any point in time. If you want to know more about writs of habeas corpus, click on the link here to watch a video that I've previously done on writs of habeas corpus. If you want to know more about direct appeals, click on the link here to hear me talk to you more about direct appeals and what that entails. Today, I strictly want to focus on motions for new trial to let you know what you can do and what you could file in a motion for new trial that will get the court's attention right away in order to help you move forward in your appellate process and post-conviction process. So let's begin. In a motion for a new trial, what we really try to do is bolster the record of what may have occurred either during trial or sentencing that could help a judge determine whether or not there was ineffective assistance of counsel or other issues that may have occurred during the course of your case that have been deemed to be constitutional violations that could help determine if you should get another day in court. I want to specifically focus on ineffective assistance of counsel, though, because that is the most prevalent claim in a motion for a new trial and is probably one that is most readily used and most heavily argued in order to help give a trial judge another chance in court. The benefit of the motion for a new trial, for starters, is that it's filed within the first 30 days. It goes directly back to the court where your case was held, and it gives you an opportunity right away to overturn that conviction because the court still has jurisdiction of your case. That means that your case still has not moved forward into an appellate court where there's a panel of judges that hear your case. This case is still stuck in kind of in limbo where the judge has technically 75 days in the event that you filed a motion within the first 30 days to make a ruling, either to grant you a motion for a new trial or to deny it. Why do we want to file it, though, to begin with? Well, the reason you want to file it is because if you do, you can expand on the record that's already in existence and bring certain issues into the case that have not been there yet. So, as an example, you were charged with a felony. That felony went on for almost an entire year. You are set for trial. Your lawyer that you have hired prepared for trial, supposedly. You went to trial. There was a conviction after trial. And now you're in a space of where you've received the verdict and the sentence. What that case does not have is information about, well, what happened leading up to trial, what happened during the course of the case, what happened in your communication with your attorney, what happened with your lawyer's preparation for both your guilt-innocence phase of your trial and your sentencing phase of your trial. What communications did you have with your attorney? Who did your attorney interview? Who did your attorney not interview? What kind of experts came in to testify at your case or did not come in and should have come in? What kind of investigation was conducted? All of these issues are not part of the record, and we want to make them part of the record. And so the way that we do that is we file the motion for a new trial. We develop that record within the course of that 75-day period, and we present it to the court and make it part of the record. In the event that it's done effectively and correctly, it gives you a really good chance, probably your best chance straight out of a conviction in order to get you the next day in court or a new day in court. It's much harder to do that on appeal, and it's even harder to do that on a writ of habeas corpus. So I've come up with a list of things that we can discuss that may have occurred in your case with respect to ineffective assistance of counsel and motions for new trial. So number one is failure to investigate and present certain evidence. Number two is failure to call witnesses. Number three is failure to object to inadmissible evidence. Number four is bad plea advice or failure to convey a plea offer. Number five, failure to request or object to jury instructions. 6, failure to file, litigate motions to suppress issues. Number 7, failure to investigate and present mitigation evidence at punishment. Number 7, failure to address juror bias or misconduct. Number 8, failure to object to prosecutorial misconduct. Number 9, failure to use certain expert witnesses. Number 10, failure to preserve error, protect appellate rights. Number 11 is a lack of preparation and communication. And number 12 is failure to raise competency or mental health issues. All of these issues that I've just listed can come in certain layers. So they could either be used at guilt-innocence phase or at punishment phase, just depending on what type of case you had and what you had kind of going on during the course and leading up to your day of trial. Now, most importantly, I know that this video, we talk a lot about trial cases. This does not only pertain to trial cases. A lot of people that come to my office and hire me to do a motion for a new trial, and some of the most effective cases of where I have been successful in getting people a new trial has been in circumstances of where they simply pled guilty and have had either a sentencing hearing or just have pled guilty to a particular case and have now received a sentence. And they come to me saying, well, I was not explained this, and I did not know that I could do this, and I didn't know that I could call certain witnesses, and this was not explained to me. And so we could file a motion for new trial in that circumstance as well, and it could become part of the record, which we then can appeal to the Court of Appeals because we've now made an appellate record. So all of these issues that I talk about are both for people that have gone to trial and people that have not gone to trial, but they're specifically tailored to individuals that have been convicted of a crime, either misdemeanor or a felony. So first, let's talk about failure to investigate and present evidence. So a lawyer has a duty, and basically there's a certain prong of standards that a lawyer must comply to pursuant to what's called the Strickland standards. This is the seminal case from the Supreme Court, which is Washington versus Stringle. Specifically, what we look for in an ineffective assistance of counsel claim is a two-pronged test pursuant to Strickland versus Washington, which is a Supreme Court case. So one is that you have to prove that your lawyer was deficient, and two is that the deficiency was what prejudiced the client. So when we talk about deficiency, we talk about the fact that the lawyer's representation fell below an objective standard of reasonable approach to how they practice the law in the criminal setting. In the second prong of where there was prejudice that occurred, you have to be able to show that but for counsel's errors, the results would have been different in your case. The second prong is where you have the most difficulty in being able to prove that the result would have been different, but I will guide you and let you know what we can do in order to help prove up that second prong and make it as strong as possible for your case and for your situation. So first, let's talk about the failure to investigate and present evidence. A lawyer has a specific duty to investigate exculpatory evidence or issues that the client has brought to the table and has expressed to the attorney that, I have an alibi or I have a witness that would be really helpful for my case that you need to talk to because this witness was there when the crime happened, or this particular witness knows about me and knows about my character, and it could help mitigate the circumstances of what has occurred. So it's important that you are able to communicate with me if you have hired me to help you with your post-conviction situation and tell me specifically what was the extent of your communication with your attorney who you have hired to help you during your trial case, and what questions did he ask? What questions did he or she not ask? What do you believe would have helped your case that you felt really strongly about that could have potentially given a better understanding of who you are as a person, or how your case may have been navigated differently that could have helped a jury potentially see you in a different light? The second thing that I had mentioned previously was failure to call specific witnesses. Obviously, these all interplay with one another, but ignoring available witnesses could have helped support your defense, in addition to the fact that your lawyer has an obligation to interview not only witnesses that you might have brought to the lawyer's attention, but your lawyer has an obligation to interview the state's witnesses as well, because you want to be able to know what these state's witnesses are going to testify about. Now, is it possible that those state's witnesses would not talk to your lawyer or to an investigator that your lawyer has hired? Sure, that is a distinct possibility, but it doesn't mean that your lawyer doesn't have an obligation to do so. And so what we would do if I was hired is within that 30-day timeline, if we can, we would get an investigator and go out and talk to the witnesses. And go out and talk to these potential witnesses that either didn't come into trial, or go out and talk to the state's witnesses that testified, and ask them specific questions that could help shed some light onto your case and onto your situation, that will give a different kind of lay of the land or perspective of what could have happened, and what we believe was a much more tailored presentation of your case that should have been heard by either a judge or a jury. And we obviously have that 75-day window in order to do that, but obviously it's much more effective if we can get everything done within the 30 days. So as I always tell people, as soon as somebody calls me, if it's within the first 5 days of conviction, I'm putting everything aside and I'm doing these things that are failure to invest, what your lawyer failed to do, right? Fail to investigate certain things, fail to call certain witnesses. And we kind of develop your case from the get-go in a very, very small window. The next thing that I had to mention was failure to object to certain inadmissible evidence. So this is a very hard thing to develop because we don't have the physical record typically straight out of trial, because it takes a long time for a court reporter to get that record together. But if there was a whole slew of evidence that occurred, for instance, just as an example, a gang-related violence case where there was a murder case, for example, where a death had occurred and the allegation is that you have been or a family member has been tied to gang-related activity, and there was no investigation regarding gang-related activity. It was clearly biased testimony that you or your loved one or whoever it may be was related to a gang, and it clearly impacted a jury's ability to favorably look at the situation and consider the situation for what it actually was, and it helped them develop this very distinct bias toward you and make them scared of the fact that, oh my God, well, this person may have been in a gang and we need to be able to convict that person. I've had cases like that. And so these turn into improper arguments by the state. There's a whole developing factor that occurs because that is a big part of what the state's case was, for example, right? Is that this was all gang-related violence, which technically it may not have been. And maybe your case was a really straightforward self-defense case that turned into a case that was tried all about gang violence. And so we may have a window of opening there to argue to the court directly that this was distinctly unfair. And we need for the court to review this evidence immediately because we feel that there was prejudice and bias that occurred in your case, and we want to bring that to the court's attention. Next thing that I had mentioned was, and this is strictly in a situation of where you have chosen to plead guilty and you've now been sentenced. So bad plea advice or failure to convey a specific plea agreement as well. So bad plea advice, for example, for many years, and this is less and less prevalent now, but for many years, for example, lawyers would fail to let their clients know that your plea may have immigration consequences, right? You're a green card holder. You've been charged with, let's say, minor felony offense every felony offense is serious, but for minor, let's say a small amount of possession of some sort of narcotic, and you pled guilty, right? And so your lawyer has failed to communicate to you that by you pleading guilty, it could result in significant consequences for purposes of your future immigration status. Or a much more prevalent example is in cases that I've had probably more than 5 or 6 occasions now, just in the last few years, where individuals have pled guilty to an assault family member case, which could have been a misdemeanor, and that case then resulted in you having what's called an affirmative finding of family violence. Well, what is an affirmative finding of family violence? It means that it's gone on your record. Leasing offices, banks, loan officers, everybody could see this information. And so you become this pariah now where you're much less likely to be able to obtain certain things that other people in society are able to do. People with an affirmative finding of family violence, for example, can't even go to their kids' soccer games or attend certain school events, so on and so forth. So if your lawyer failed to tell you about these things and your lawyer failed to advise you of the ramifications of your plea agreement, this is a way of us being able to communicate to the court that this is an effective assistance of counsel. That this lawyer knew that this person, for instance, has licensing from the state of Texas, or this person is currently in school to become a nurse and they're unable to become a nurse now, or they're not going to be able to become licensed because of their conviction. So this is probably one of the more typical allegations that we would make straight out of a plea agreement situation as opposed to a trial. All right, next was failure to file and litigate a motion to suppress. So, ignoring Fourth and Fifth Amendment right violations, search and seizure issues, circumstances of where you may have been subject to a very hostile interrogation from the police where clearly you should have been given the ability to have a lawyer present, or, you may have even said, I don't want to talk to you, but they kept pressing and you started talking, but your lawyer never developed enough of these facts and never filed a motion to suppress. Well, this is your opportunity to bring that to the court's attention and say, hey, there was a Fourth Amendment violation here, and it never got played out in court. And we need to be able to bring that to your attention now before the appeal moves forward, because we feel like this case had a huge issue from the very get-go and it was never properly developed. This is your opportunity to develop it, is when we can file a motion for a new trial. The next part is probably one of the more expensive things to do in a motion for a new trial, and one that is, I think a lot of people don't understand how to actually even navigate it, but it specifically revolves around utilizing expert witnesses and a failure to raise competency or mental health issues within the confines of mitigating evidence, specifically in terms of a punishment case. So the examples that I would provide in this context would be specifically where you went to trial. Again, guilt, innocence, you're found guilty, your case moves on to punishment. It's still before a jury, but could also be before a judge. But I'll give you the example of you've been found guilty, your case is now going to punishment, you're still before the exact same jury that has now found you guilty, and your lawyer's job at this point in time is not to battle state's experts on, evidentiary issues or what happened during the course of the case, or whether or not this was a self-defense issue or something else that may have occurred with respect to that investigation. This is strictly about you. It's about you as a person. It's about your family. It's about your future. It's about your survival. It's about prison, right? So there's a lot of things that kind of start to develop in this punishment area. Most lawyers are never prepared for this part, because what lawyers do typically when they go to trial is their focus is strictly on, well, I need to be able to defend my client, and I need to be able to show that the state can't prove their case beyond a reasonable doubt. And they tailor their entire presentation and their case around the evidence of the case, what the case consists of, the investigation of the case. Those are the more complex issues. And of course, that's what you're going to be more prepared for. But the likelihood of you being found guilty percentage-wise is still higher than you beating your case, right? So if your lawyer was not prepared for punishment and your lawyer did not tell you, hey, we could use expert witnesses here to talk about the thing that happened to you 20 years ago where you were hit upside the head, or, your family history of severe mental health trauma, or issues that may have occurred during the course of your last, 4 or 5 years where you may have been in a severe car accident, or, you have other issues that revolve around your existence, or the way that or what you've planned to do with your future, or what your family circumstances look like as a whole, or things about your kids, or things about your parents, or whatever it may be, right? There are things that have not been developed. And not only have they not been developed, in order for you to be able to maybe use an expert such as a psychologist or a psychiatrist or another type of expert that could come in and testify potentially about who you are as a person, your lawyer may have also not communicated with a whole slew of people that could have come in to testify on your behalf to really tell a jury who you are as a human being, right? So family members, friends, individuals that know you best in the community, these are all important people that can advocate for you and to display a measured sense of leniency that a jury should be considering in order to give you the best shot. And if your lawyer didn't do that, believe it or not, a lot of lawyers don't do that. It's ineffective assistance of counsel, because at the end of the day, that's where you could show that there was a reasonable probability and a likelihood that the result or outcome of your case would have been different, right? You went to trial and you were found guilty and you got a life sentence. Well, there's a pretty distinct possibility that had many people come to testify on your behalf and a jury was able to see who you really are, that your sentence wouldn't have been a life sentence. It would have been 35 years or 40, right? Which is a huge difference for purposes of parole. So these are some of the most significant and more likely to see issues for purposes of ineffective assistance of counsel in a motion for a new trial. Obviously, this is not an all-encompassing comprehensive list. There could be more issues, and I can certainly develop more issues if I know what your case is about specifically. So I would love to be able to help you in your situation or in a loved one's situation that's going through something like this. I have an incredible amount of experience with this and success in developing these types of issues. And if you want to talk about your case or a loved one's case, I do offer free consultations. Click on the link below for more information. Thank you, and I'll see you in the next video.